Kathy Hardcastle.
Great. Morning.
Good morning, Judge. How are you?
I'm fine.
Good morning, Your Honor. Karen Mishler on behalf of the state.
Craig Mueller, back Mr. McDonald, Your Honor.
Okay, this will be in case number C-335-284. This is on the state's motion to remand.
That's correct, Your Honor.
Before we begin, Your Honor, respectfully, I was surprised to see you. It's good to see you, but surprised to see you on the bench. I understand that you actually presided over the underlying family court case, at least in part.
Yes.
I would think it'd be appropriate that we set this over then until Mr. Judge Israel can get back.
For what reason?
Because there's apparently some lawsuit Mr. McDonald told me about this morning that you were the defendant in a 1983 action.
Not aware of any lawsuit.
Oh, you.
And it's previously been held that the opponent of the lawsuit does not constitute a basis for recusal.
Yes, Judge. I think Your Honor, I think you best that Judge Israel will hear this.
My motion is denied.
Your Honor, may I be heard?
Yes.
And Your Honor, when the defendant Michael McDonald was released on his own recognizance last April by Judge Israel, one of his release conditions was to have no contact with the individual, his ex-wife being Candace Ruiz. Approximately a month ago in June, he then mailed a number of items to his wife's address, although they were addressed to the children. When I filed my motion, because this was in violation of the no contact order, I did include some information regarding the family court case. Just I wanted to make clear to Judge Israel that the defendant was no stranger to no contact orders. He understood that no contact meant no contact through the mail, and that he wasn't supposed to be having contact with the children anyway. I've spoken with Candace Ruiz's attorney in family court case, Michelle Hauser, and she's advised that since September of 2017, the defendant wasn't supposed to have contact with his children anyway. Additionally, since I filed my motion, a couple of things have come to the state's attention. Last week, the District Attorney's Office was holding a CLE. At the conclusion of that CLE, when there were about 3 attorneys from the DA's office still remaining there, the defendant showed up at that location, came over to Nell Christensen, the attorney in charge of CLEs, and stated that he wanted to attend all of our CLEs because they were supposed to be open to the public. He became very argumentative and belligerent and demanded to be attending our CLEs. And when asked who he was, he stated that he worked for Craig Mueller. He then grabbed our CLE schedule for the rest of the year and left with it. So we're now having to send investigators to all of our CLEs out of safety concerns. And this brings up an additional concern. If the defendant is actually employed by Craig Mueller, we potentially have a violation of Rule 1.8 of the Nevada Rules of Professional Conduct, which prohibits business relationships between a defendant and between a client and an attorney unless certain criteria are met.
Okay. Counsel?
May I see, is there some evidence I can see or peruse ahead of time? Ms. Christensen write a statement of any sort? The first I've heard of this, I got in last night about 6 o'clock and found out that there's apparently some other allegations. The surprise is utter and complete.
I don't believe a police report was written, but.
Well, okay.
All right. Anything else you wish to present?
Well, yes, Judge, a few things. Number one, Mr. McDonald's already actually, there apparently was, and I'm not a family court practitioner, there apparently was a family court order of no contact, but the answer was it was clear or not whether he could send presents or not. He sent 2 gifts, that's it. No nasty notes with them, no diagrams, no nothing. So they apparently put the matter back on calendar in 3rd of July for clarification. May I approach?
Okay.
For clarification. And Judge Moss clarified the order on the 3rd that there was to be no contact by sending no gifts. But previously, before that order was clarified, that wasn't a violation. We've got a trial in about a month and a half. We will be ready to go. Mr. McDonald is not violent nor a threat to the community. He has had no allegations of violence. He has stayed substantively away. I know you know, I do not believe that even the sending gifts to the child were even, strictly speaking, a technical violation. As other allegations, I just asked my client to give me some, or my colleague to give me something to work with so I can address it.
Right. Anything else?
And Your Honor, the issue is the defendant violated the order of no contact that was issued by Judge Israel. The family court's orders are only relevant just to show that my point was just that he's no stranger to no contact orders and he knows how they work.
Thank you.
So with that, I'll submit to the court.
Judge Israel actually, and last time we were here, which is, I specifically actually read Judge Israel's text back to him as what he's said. Nothing in Judge Israel's initial order was violated. Said no contact, stay away from it.
Yeah. No contact, nor you to cause anyone else to have contact, and that includes the U.S. Postal Service or anyone else. Also. But I don't have to make a determination today as to whether or not there was a violation. He has a contempt hearing coming up. What I do need to look at is, has there been enough of a showing for the court here today to be concerned about his ability to remain out on bond with the electronic monitoring device, and whether or not his actions are starting back with what he was doing that previously led to all of his problems before, of escalating the type of behavior. I would note that back in family court, he constantly violated orders. He would always insist that the order said something else. There was the issue regarding adding a line to an order. I was the one who found that he was a potential danger to his children because he lied to the court about surrendering his weapons after he'd been ordered to surrender his weapons as one of the conditions. And that because of his bizarre behavior, putting a tracking device on his wife's vehicle, engaging in a course of conduct, I found that he was a potential danger to his children. I suspended his visitation with his children until he had been seen by a mental health specialist to determine whether or not he should be on medication. Because what was presented to me in family court was that he refused to take his medication. And he also needed to follow a course of counseling if that was recommended as part of that risk assessment. And then subsequently, there was a search warrant at his house based upon threats, and he was found in that search warrant to have made not only threats against his wife, but threats against the judge that was handling the case, which was not me, but the other judge. And then he had his domestic violence cases pending in municipal court. He was found guilty on one of the cases, sentenced to the maximum of that case, and then he was convicted on the second case, and that case was run consecutive. So he's been in jail for a period of time. He got out in April, I believe it was.
Yes, sir.
And then in June, we're back here again. Then he kind of shows up at the gate downstairs wearing a bulletproof vest. You gotta wonder what's going through his mind, and that he's showing up, according to the allegations here this morning, at the District Attorney's CLE, misrepresenting his position as an employee of your office. And so I'm seeing the same type of conduct, and it's an obsession It's a escalating course.
Your Honor, thank you. You've actually enlightened me on a couple of things that I wasn't aware of. May we, I will get Mr. McDonald evaluated and have him followed up. In the time I've dealt with him since the last 4 or 5 months, this is the first substantive allegation that there's a problem. And candidly, it's sending gifts to his kids.
The allegation has been in the past that he's bipolar. He
With-
supposedly was seeing a therapist. It was adding a line to the letter from the therapist that,
allegation I'm familiar with, Judge.
Yes.
Respect, I wasn't aware that there was an allegation he was bipolar. Having said that, now that my eyes are open to it, I can act upon that as an officer of the court. I'm going to ask that simply you give me an opportunity to address that now that I know there's potential mental health problems.
and I think you can address that. My concern is, I think he's starting to create the impression that he is a danger. His escalating behavior as the pressure of a trial coming up starts to impact him. Quite often we see more acting out. I'm not sure that he is capable of controlling himself because he wasn't before.
Thank you, Your Honor.
Even after numerous hearings, even after numerous orders. And now we're seeing a continuation of that type of behavior. So based upon that, I am granting the motion. You can have him evaluated by a psychiatrist.
Put your hands behind your back.
Thank you, Your Honor.
Put your hands behind your back.
Craig, can you please tell him I just got a mental eval already done?
Dude.
Cosmo.
Stop, come on. Come on.
Mike, calm down.
Hands behind your back.
Mike, calm down. Just relax. Deep breath. Mike,
guys.
take a deep breath.
I got a mental eval. I just want to see my kids. Come on. I've done nothing.
Mike,
Just take it
calm
backwards.
down. Dude, take a deep breath.
Please, guys, come on. You're gonna really throw me in jail because I missed my kids. Come on.
Assistance in 15 Charlie. 15 Charlie.
Stop. Come on, please, guys. Please, I don't want to. You got it? Please, guys.
Let's just hold him. Come on.
Mike,
All right.
stop fighting with the guys.
Hey,
I'm gonna take her.
Mike, stop fighting with them. I don't have to go over there and
I'm
help
gonna
them with
tase
the cuffs on you. Don't
you
fight with them.
understand? I'm gonna
Don't
tase
fight.
you.
Don't fight with them. Put the handcuffs on. Mike, put the fucking handcuffs on. Or I'll put them on myself.
Craig, come on.
I'm on your side, Mike, but you're out of line.
This is ridiculous. There was no order saying I can't see my kids. It's a CLA thing.
Mike,
I just happened to come upon the author. I talked to a lot of authors. Come on, guys. We're good. I just want to see my kids. Now I'm getting prosecuted as an enemy of the state. I just want to. I've done nothing.
Code 4 up here.
Come on.